Hi, I'm Debbie Morais, and this is Legal Matters, the program that's been designed to address some of the timely and sometimes critical and contentious issues that are facing consumers and businesses today. It's legal information, it's practical solutions, and straight talk about a wide variety of topics that are facing people in their work and their home life. Last session we were discussing the challenges that face immigrants who are grappling with the legal system, how their rights could be denied, compromised. So today, in this segment, we thought we would discuss issues that are facing people with disabilities. Wholly healthy people certainly have trouble coping with some ordinary daily life kinds of issues and certainly have trouble grappling with how to maintain their rights. We thought that with the number of 1.8 million people in America who are currently listed as having disabilities, certainly they too have many occasions when their rights are denied or compromised. We thought we would explore some of those laws and a few of the cases that have been affecting people, and there are certainly, as we found, so many to deal with. With us today to explore our legal issues again, Jackie Grasso and David Bazar from Audette Bazar Cordero Grasso Law Firm in East Providence. And I think we should probably begin, if you don't mind, with just everyone is entitled to have protection. Lately there's been a lot of interest in the news about people having developmental disabilities or people who have mental challenges or mental illnesses. They have rights. That's an easy thing to deal with. How do you know when your rights might actually be compromised? What are the typical rights that are being compromised or denied?
Well, I've seen it more often in the employment area with the people that are being having issues because of their disability. So, for instance, under the American Disabilities Act, if somebody does have a physical or a mental impairment that prevents him or her from doing major life activities, work is one of them, obviously, then the employer has to make reasonable accommodations. And if the reasonable accommodations are not made, then somebody could essentially sue under the American Disabilities Act. In the public sector, with, for instance, like a beach, for instance, now you see handicap parking places. Many years ago, you never saw that. Because of the American Disabilities Act, it gives individuals the right to file a claim against the city or the state that doesn't have handicapped parking places. Why? Because they're not being reasonably accommodated. Or I've seen some cases where there aren't enough handicapped parking spaces.
Sure.
Or they're not big enough because they have to be according to certain dimensions.
There's a wide variety of laws that protect people with disabilities. As Jackie was saying, there's the Americans with Disabilities Act, the federal ADA law, that applies to certain size employers. And
over 15.
Right, and the public and what they're entitled to for accommodations in public places. There's also housing laws that apply to people with disabilities. There's other equal rights protections that could apply. So you can give us some specifics in a wide variety of different areas, and we can tell you which laws may or may not apply.
Well, when we think about that there are cases about access to public entities and services, I think Jackie was referring to some of those. Let's look at that for a moment. So if there is someone who has interest in going to a specific restaurant, and there may be a restroom facility but not a ramp.
So it's not handicapped accessible.
At least to get in, but once they're there, they manage to make provisions for the restroom.
Sure.
What kind of recourse does someone have, and what kind of responsibility does the owner of that restaurant have to accommodate them?
Well, when the law was originally passed, I think in the early 90s, there was a provision in the law that said that an entity had to make reasonable accommodations, provided it didn't create an undue financial burden on the entity.
Right.
So if it was going to create that much of a financial burden on the entity, then they would have a defense. If not, then the person sues under the ADA, the restaurant would thereafter be ordered to remedy the situation.
Now, there's a couple of other factors that do follow from some of the things you're asking here. When somebody opens up an establishment to the public, a restaurant, as you're saying, they have to follow certain rules and building codes, zoning obviously, and some of those things will be impacted on people with disability. The public restroom has to have handicap accessibility and handicapped stalls, those types of things, railings that people can use. The building itself to get into has to have some handicap accessibility. As Jackie is saying, though, the zoning laws and the building codes that apply also have some ability for people to be grandfathered in depending on historical buildings and other things of that nature.
That applies mostly with historical.
Right.
And if you are looking to to own that piece of property, if you see that there's clearly no way to have handicap access, to put in a ramp for the way it's constructed on the street corner or whatever it is, does that mean you clearly should just shut that down and not use that as a piece of property? Or, as you said, there are opportunities at times for grandfathering rights. What would you suggest if someone is thinking about exploring those opportunities?
I would think once it passes owners, then you're no longer grandfathered in.
Well, and changes use.
Yeah.
A change of use may take some of that away. However, the rules that are in place for building codes and zoning and all of that, as it affects people with disabilities, has, as Jackie was saying, some reasonableness to some of the things that you can and cannot do. If you cannot physically put in a handicap ramp but have some other way of accommodating someone with a disability, it may pass muster. May is the big word there. It depends on the exact set of facts and circumstances.
Now, if they tried to remodel the building, now you're changing, maybe not the use, but you're changing the construction of the building. Because they're remodeling, they have to get a permit from the town.
Correct.
And pursuant to the building code, they have to comply with the ADA.
Absolutely. And it depends on how large a percentage of, say, the remodeling is to the total square feet of the building or the value of the building. All of those things are issues that will come into play in determining whether or not you have to now bring it up to other standards than the standards that existed when the building was built at the time.
Okay, and that's from the owner's perspective or the entrepreneur's perspective. And for the disabled person who really might like to be in that restaurant and it doesn't quite accommodate it, too bad for him, or should he actually raise some issue? And if he did, what's the process? What does someone do if they think that they are justified in pursuing this?
Being discriminated against perhaps because of their disability, or somebody is not following the proper rules of the ADA or whatever other laws may apply. They certainly can bring suit. I mean, that's always a possibility, and it can be either on individual basis or perhaps even in a class action type of suit, which we've talked about before, is where you sue for a whole class of people, a whole class of disabled people. The issue would be is, first and foremost, what is the violation? Is it because there's no ramp, as you're saying, and there could be a ramp? You know, that is probably a suit that could be brought and settled by the building of a ramp.
Is the issue whether or not there actually just could be a ramp, or whether or not there needs to be one? Maybe it could actually fit. Does that mean that the employer or the owner is obliged if someone raises that issue?
Right. When we're talking about the ADA, and as Jackie raised it initially, usually that's referring to people in a workplace situation.
Okay.
It would seem to me that what's happening in a public accommodation type of situation is there's a host of other laws that may apply, including building codes and zoning and all of that, and there may be other rules that you're not complying with that you have to. And so you have to look at the individual circumstances. When was this building built? How long has it been used as a restaurant? If it's the White Horse Tavern in Newport, for example, that's been operating continuously since
1800s, 1700s?
Yeah, the rules that apply may be different than if I'm opening up a restaurant in an older building for the first time.
But not only that, it's also a private institution. So the rules that apply there are going to be much different than a public institution. Okay?
Potentially.
Yeah.
Right, but when you're holding yourself out for business to the public, you then have certain rules you do have to follow.
Let's talk about children for a moment. There are, I think, 5% of that 1.8 million who have some disabilities, and if it is a learning disability, or maybe it's a physical handicap or a mental challenge of some sort, obviously there is usually associated with that some cost to the educational system to accommodate that.
Yeah.
Certainly there are programs in place, and parents have every right to pursue that. What should they do if they think that still there isn't enough protection, there isn't enough of a provision for their child, regardless of whether it's a mental or a physical or a developmental handicap? What happens?
So you have two overlapping areas now. You also have the ADA, but then you have
The right to an education.
Right to an education.
And there's, the public schools have an obligation
right.
to provide a program, and if somebody needs an individualized program created for them because
The
of...
IEP?
Right,
Oh, yeah.
exactly. Then there's a process that you can go through, which is you have the school try to develop one. If you don't think they've done a correct job in doing it, you can appeal either to the school board or to the Department of Education, and you're entitled to have some review of that program, and you can tell them why you don't think they're meeting the needs of your child in particular.
And if they still don't satisfy the needs, then ultimately you can file a lawsuit against the school department.
We've talked from time to time about the do-it-yourselfers, the things that you could do online. When it gets to be a situation with disabilities and a lawsuit, is this something that any individual could pick up the banner on himself or herself, or do they really truthfully need to have a lawyer to do this?
There are so many different areas that are affected with disability law that I don't even think there are lawyers that can cover every single area because it gets so specialized. For example, there are lawyers who handle these IEPs, the Individual Education Plan, that know that law and can cover that. There are lawyers who know the building codes and the zoning laws and the requirements of a company that's holding itself out for business to the public, what they need to do. There are lawyers who specialize in the housing laws, that if somebody's being discriminated against because of a disability or otherwise. So this is an area of the law that I think is so specialized and so difficult to deal with on an individual basis as a lawyer, never mind as a person, that I think you need to find a lawyer who understands the area of law that's being governed here.
And that really does require specialties. You're saying
Yeah.
if someone goes to a lawyer, they should actually ask what their history is or what their field of specialty is, because,
Have you handled a case in this area before?
or how many, or
Right.
whatever.
States do have legal services for people who feel as though they're being
Discriminated
yeah,
against
yeah,
because of a disability.
Yeah.
Fair enough. Now, not speaking necessarily about a child's issue, although I suppose this could be, I understand, and we understand, that determination of a worker, say, for example, being disabled, or someone being disabled because they're in a wheelchair, or they're blind, or they're deaf. What about alcoholism and drug abuse?
That does not qualify under the ADA. That's not considered a disability.
Right, and not for Social Security purposes either.
No, no.
What about if someone is a good worker, has always been a good worker, and develops this problem? Sorry, we'll have to let you go because you were late. There's a cause. You didn't show up. You didn't perform your duties.
Now you have somebody who's somewhat insubordinate.
Right, what's the underlying issue, I guess, is what you really have to get to. Just like the underlying issue for the alcohol or drug dependency, the alcohol and drug dependency, as we said, it's in and of itself is no longer, at one time it may have been considered a disability for certain things, but it's no longer considered a disability. But is there an underlying mental issue or problem that you might be able to get to? This is where lawyers earn their money, is not just to look at the symptom, but the problem, the cause.